Hi, let's talk contracts. How many of you have just signed a contract without even reading it? Let me tell you a story. I love stories. I had a client once who was being sued for not sticking to his part of the bargain, that which he agreed to in a contract. He was upset because he did not get what he thought he'd be getting, and then he stopped paying. Or in contractual terms, we call that ceasing performance. When it came to the time for his testimony, the question put to him by my opponent was quite simple. Did you read the contract? He said no. He also continued to testify that he indeed signed the contract regardless of not reading it. Still, he wanted to claim they didn't do what they were supposed to. Unfortunately, that did not go down well with the judge for him. He was a businessman and should have known better than to sign something without reading it first. So at that backdrop, let's look at contracts. Even if you're not a lawyer, you need to read a contract. So I'm going to give you 5 tips for the top 5 things that I think that you should look out for when signing a contract. Number 1, check the basic details. This sounds fundamental, but you'd be amazed at how trusting people are. Check the price, obviously, and the deliverables. Make sure that what you talked about with the other party is covered in what the clause reads about the deliverables. For example, if you're buying a phone, check the make and the model to be what you exactly wanted. Number 2, be sure that your rights are protected. A party who gives you a contract normally has a contract that is drafted to protect their rights. Remember, they've spent time and money on making sure that that contract is drafted for their interests. They're not interested in protecting you. That is your job. Interestingly enough, in contractual interpretation, there is something that protects you, which is known as the contra preferentum rule. Yes, I'm a lawyer. I can't get away from the Latin. This rule basically means that where there is doubt about the meaning of the contract or ambiguity in a particular clause, the words in the contract will be construed against the person who drafted it. Sometimes companies add the exclusion of this rule to business contracts. And this is something that you should check for, especially if you did not obtain a legal opinion before signing the contract, because that means that if there is an ambiguity, that rule will not apply if it was excluded. Number 3, thirdly, be sure to know what the duration of the contract is and whether you are able to terminate the contract earlier. As business people, we generally do not engage in business relationships trying to ensure that we can end them. The whole idea of business relationship is exactly that, the relationship. But just as in love, business relationships do end, the business divorce. This is the purpose of having a contract in the first place, not for when things are going well, but rather for when the relationship sours. So check the termination clause. Can you exit the agreement before the period is over? Are there any penalties to do so? And are you willing to accept these terms? Number 4, liability. If something goes wrong, and it can sometimes go very wrong, what are you in for? Also, what can you hold the other party liable for? Generally, companies will draft liability clauses to cover themselves, but you as the contracting party may not be covered reciprocally. So check for a limitation of liability and decide whether such a clause is acceptable to you. Also be ensured that when nothing is stated about your liability contingency, you are willing to accept unlimited consequences in the event that something goes wrong. Lastly, number 5, don't assume. Clarify any assumptions. When entering into a contract, the parties are generally friendly towards each other. This is the time to clear up any potential issues. Because when things go wrong, you can be guaranteed that you will probably not agree. Not on much anyway. That is exactly what a contract is for, to clear up any ambiguity in writing and to avoid misunderstandings. Assumptions are probably the most difficult part of any contract. Don't worry about appearing dumb or difficult. It's better to clarify now exactly how something works than to find out later that you and the other party were thinking of two different meanings. When clearing up these assumptions, as a bonus tip, do it via email. That way you will have a record of it. Now, these are obviously not the only things to look out for in a contract, but merely my view of the top 5 things to check. Best advice, get legal advice. If you don't have an attorney or in-house counsel, consider outsourcing that function to ensure that you are always protected. That's it for today. Have a great day.